Now we'll discuss different terminologies used in the field. So first terminology is act and omission. Whenever we are active, we are doing some act or we are not doing some act. In the law of torts, some acts are done, and because of that act, if some right is infringed, some person's right is infringed and he is injured, so liability arises. Similarly, some omission is done, and because of that, that person faces some injuries, liability arises. For example, if we are pushing somebody, it's an act. If we are taking out some item of the person, it's an act. If we are issuing memo, it's an act. If we are issuing transfer orders, it's an act. What is omission? For example, if one nurse is expected to inject the medicine at special intervals, for example 2 o'clock, she failed to inject the medicine. So failure of her injecting the medicine is her omission, and because of that omission, the patient suffered more, suffering increased. So this is the case of omission. So in law of tort, any act or omission which infringes the right of other person leads to injury. So that is known as tort. Tort means civil wrong. So here I mentioned tort means civil wrong. There are two types of wrong: civil wrong and criminal wrong. So all the things which is not defined in the criminal law, mostly they are the civil wrongs, and civil wrongs are known as torts. Civil wrongs are torts, whereas all the acts which are punishable in Indian Penal Code or any other penal statutory provisions, they are known as crime. So torts are uncodified, crimes are codified. If not mentioned, then it is not crime. And in both cases, where tort is committed or crime is committed, liability arises. Liability of the person who commits the tort or who commits the crime, liability arises. So because of the different nature of tort, different nature of crime, liability is also different. In area of torts, the major liability is damages. Damages means in the form of compensation, some amount is paid to restore the previous position. And punishment in criminology, in law of crime, in criminal procedure code, in IPC, there are so many provisions where punishment has been provided. Imprisonment, life penalty, and so many punishment. There are five types of punishments provided in the Indian Penal Code. So this is the way of understanding. Whenever it is crime, it's a punishment. Whenever it's a tort, civil wrong, it's damages. In ESIC, if some employer fails to comply, that means omission. Try to understand. In ESIC, when some employer fails to comply, it's omission. When some employer gives some forged document for inspection, that is act. If some forged document is producing for the inspection purpose, that is act. So that act is also punishable. And sometimes he is not producing the records or he is not paying the contribution, that comes under omission. And in all cases, major cases, damages are imposed. Some 5%, 10% extra charges imposed. Only in some cases, criminal cases are filed, and for that punishment is imposed. Now, the very important terminology, that is known as doctrine of separation of power. Everybody knows power corrupts and absolute power tends to corrupt absolutely. Power has tendency. Generally, power corrupts the person, and absolute power tends to corrupt absolutely, full corruption. So that is why there is separation of power, and separation of power is based upon the principle of res politica. The doctrine of separation of power is forerunner to all the constitutions of the world. Wherever constitutions were framed, the first thing was kept in mind is separation of power. There has to be separation of power. If power is concentrated in one person, he will become dictator. There will not be any rule of law. There will not be any constitution. So, for enforcing rule of law, separation of power is required. Here we will understand. Generally, separations of powers are divided in three parts. One is legislature, another is executive, and third one is judiciary. So there are three organs of the government, and these three organs of government functions based upon the separation of power. Each one is having separate power. No other organization or instrument is authorized to encroach the area of another. So jurisdiction is defined. Judiciary jurisdiction is defined. Legislature jurisdiction is defined. Executive jurisdiction is defined. They will not encroach into the area of their other jurisdiction. So like that, it's a division of power is almost separation of power. Separation of power means division of power. So government is having all powers, and in that powers are divided. Judicial powers are given to judiciary, legislative powers are given to legislatures, and executive powers are given to executive persons. What are the benefits? The number one benefit is it safeguards against despotism. So you cannot become dictator. So safeguards against dictatorship also. Then safeguard against arbitrariness also. जो मेरे मन में आएगा वो मैं करूंगा, ऐसा नहीं चलता है. You have to go as per the power given to you. Then it facilitates check upon the working of each of the organs. Everywhere some check and bounce is there. So nobody can encroach the area of another, and everyone is having some check on the other functioning of the other organs. Helps in maintaining efficiency in administration. The very purpose of the separation of power is to maintain efficiency in administration. So in this way, separation is based. So the basic principle behind the separation of power is no concentration of power is allowed, diffusion of power needed, system of check and balance required. Such separation is required for the purpose of preserving the liberty of the individual and avoiding tyranny. So the purpose is very clear: prevention of monopoly of power, and it forestalls dictatorship or despotism. Each branch is separated from each other and independent of each other. Each is prevented from invading the domains of others. So this way, separation of power is very significant. It aims at individual liberty and it safeguards against despotism. Its basic principle of concentration of power leads to dictatorship is really true. So separation of power avoids dictatorship. Separation of power saves the people from the arbitrary rule of executives. This theory, अगर executive गलत करता है, तो the person can go to higher executive or even judiciary also. This theory laid down the principle that government should act according to certain well-established rule of law. Yes, government has to act as per the established rule of law, and each organ acts as a check upon the others. In India also, if legislature passes some act, many citizens go to Supreme Court, and Supreme Court reviews the act. If act is not good in law, that act is null and void. Similarly, if Supreme Court, so if judiciary also invaded some area, encroaches some area, legislature can make the rule. So everywhere there is check and balance. It is desirable for maintaining the efficiency of the administration. So the basic purpose for the doctrine of separation of power is to maintain efficiency in administration. Now the another terminology is rule of law. On the chapter rule of law, Professor Dicey has written very books, very big books. Professor Dicey was very much interested in rule of law, and he has written thesis. He has done PhD also, and he has written so many big books on the chapter rule of law. So basically he has mentioned 3 rules of law. Number 1 is supremacy of law. Rule of law means supremacy of law. The moment you tell supremacy of law means absence of arbitrary power. Everywhere, no man is punishable or can lawfully be made to suffer in body or goods except for a distinct breach of law. That means if law is there, one has to follow. If he doesn't follow, then only liability arises. If he follows, liability doesn't arise. So, supremacy of law is number 1 rule of law. Number 2 is equality before law. The second meaning of the rule of law is no man is above the law. Everybody is equal. Everybody is equal before the law. Right from the peon to prime minister. Everybody is equal before the law. And same has been enumerated in our Constitution of India in Article 14, 15, 16, 17, 18, 19. So Article 14 is the clear evidence of equality before the law. Then predominance of legal spirit. Here all decisions taken, legal spirit has to be kept in mind. For deciding any right or of either personal right or organizational right, the predominance of legal spirit is required. That means individual liberty is also there. Rights, freedoms, right to speech, fundamental rights, these all are parts of rule of law.